Welcome to the Professionals of the Inland Empire show with your host, John Tulac.
And welcome to another podcast edition of Professionals of the Inland Empire, affectionately known as PI. I'm John Tulac, international business attorney located in Claremont. I am privileged to be the host of this podcast featuring smart, interesting professionals from all around the Inland Empire on a variety of topics. The purpose of this podcast is to demonstrate just how talented our professionals are in the Inland Empire. So when you need a professional, you should be looking locally for that talent for whatever your business need might be. The second is to promote the further economic development of the Inland Empire. And when we have good commerce going on, we develop our economic activity out here. And then finally, you've heard it if you've been listening to other podcast episodes, that my guests are all members of Provisors, with an occasional exception. Provisors is the premier networking group in the United States, and we're all across the country now, but we're particularly strong with 4 groups out here in the Inland Empire. So if you're a professional, a lawyer, an accountant, a business advisor, a banker, and you think you got the right stuff to join us, there's contact information that you can see at the end of this podcast. So with that, I'd like to introduce briefly our 2 guests for today. We're going to be talking about employment law in California, a really dull, uninteresting, nothing ever happens kind of topic, but it's going to be made much livelier because we've got Chris Weaver, who's on the plaintiff side of the fence, and Olga Peña, who's on the defense side of the fence. And I said, these are smart, interesting people. They're also good, reasonable people. They know how to talk civilly about topics that can be controversial. So Chris and Olga, welcome to the podcast. It's good to have you here today.
Thanks so much, John.
Thanks for having us.
Well, I am really interested in finding out how you do what you do. So Chris, let me start with you. You're on the plaintiff side of things. So how did you get there? And what do you primarily focus on in representing employees?
Yeah, thanks, John. So, my background is a little bit varied as a lawyer, at least in terms of employment law. I practiced employment law for 20 years, but I started out at a couple of different big firms in Orange County. And being at big firms, typically you do defense work. That's what I did. So I represented companies for the first 10 years or so of my career, doing the same kind of stuff that I know Olga does. Representing companies in both individual actions and class actions. Once you kind of cross over and do what I've been doing now for 10 years, we tend to call that the dark side. So I left the dark side to first start my own practice, and then joined forces with a couple of other partners quickly after that. And so I'm at a small firm, Aiken Campbell Highhouse Weaver. We've been doing that for about 10 years. We represent almost exclusively individuals, i.e. plaintiffs. Every once in a while, we'll take a friends and family type case that might be on the other side, but it's rare and exceptional. So what we do, the bread and butter of what we do are individual cases. Tend not to do a lot of class action work personally. I just find that I like representing individual people in individual cases. For the most part, it's wrongful termination type cases, some sexual harassment cases, and some what we call wage and hour cases, people who didn't get paid right, as I like to say. Sometimes they didn't get paid what they were promised. Sometimes they didn't get paid what the law requires them to be paid. So, that's sort of in a small nutshell, our bread and butter type cases.
Okay. Well, thanks, Chris. Olga, over to you. How did you get to where you are? You certainly don't look like Darth Vader on the dark side of things. So there's kind of another side to this. Tell us about it.
Well, I guess we all have our names for things, right? I am a 10-year attorney. My 10-year graduation reunion is coming up from law school. Before that, I was a high school Spanish teacher. So I went from being in a classroom for 6 years to going back to the classroom for law school. And then I graduated. I've always been defense side. My very first firm was a tiny firm that did both defense side and plaintiff side. And I discovered very quickly that the plaintiff side was not for me. I've been told before when I speak to opposing counsel, I take it as a compliment when they say, "Well, why are you on the defense side? You sound so nice. You could be helping people on the plaintiff side." And I can't do it. On the plaintiff side, you have to trust in your client 100%. On the defense side, I have the emails. I see what it all looks like from the inside from the very beginning. And I know when people are lying and where all the friction points are. And I get a bigger bird's eye view of things. I think I'd just be heartbroken if I had the kind of cases where I believed in my client fully 100% and they ripped my little heart to shreds. So I don't think I could handle that part. I had a opposing counsel once look me in the eye and say, "But Olga, he looked me in the eye and he swore to me that he didn't submit a falsified document." And I said, "Well, I'm really sorry that happened to you, but he wasn't necessarily telling you the truth." So, like I said, defense side is best. I prefer smaller companies because I tend to find that people that start their own companies tend to start with very uh, kind of concern for their workforce since it's so small. They're still very much treating everyone like human beings and they kind of have this idea of trying to do right. And most small employers don't do right because it's really hard in Southern California to follow all the laws. They're very complicated and they overlap and they change nonstop. So I run into mostly people that mean well and didn't necessarily hit the mark. So
Unintentional, as opposed to, yeah, I'll deliberately get you.
Yes, yes. Not to say I've never had an I'll deliberately get you client, but for the most part, I'm very fortunate because by choosing to work for smaller companies, I get to really see humanity, and that and I've never done the big law route, so I've always kind of been working more with just human beings, and I find it incredibly rewarding.
Super. Well, I've been a corporate type for all my entire 48 plus years in practice, but corporate clients don't last long with me if they don't engage with what I call committing to good or best practices. And so uh, the most important resource I think a company has is the human resources. It's all about people. A corporation is only people. But if you don't treat your people well, you don't keep good people for long. So that's always been my philosophy. And the second thing is, this is a question for both of you. Isn't there a place for compassion in the workplace environment? We feel sorry if we have to let somebody go, if we have any ounce of humanity, and sometimes we don't let them go properly. So there's a cause of action that arises out of that, but that should be handled promptly. I mean, how do we deal with what seems to be so contentious all the time and kind of bring it down? Chris, how about you? Let's start with
Um,
you.
it's a great question. If I had the answer, I'd be doing something grander than I am. Um, you know, part of it is I do think you've kind of touched on it, at least tangent of it, which is it does become very personal, right? Uh, you know, your workplace is kind of your second home, and your coworkers are kind of your second family. And so, when somebody who's been terminated comes and makes an accusation that, oh, well, I was fired, because you didn't want to properly accommodate my disability, or even something stronger, like I was fired because of my race or whatever the case might be, you know, um, it's very easy for an employer, even a big employer, to take that very personally. And so, from my perspective, anyway, these can be very serious accusations, and um, I think a lot of times it creates a sense of betrayal on the part of the employer. And so it becomes not just viewed as a business dispute, you know, where you've got two interpretations of a contract and somebody's got to win and somebody's got to lose. Come on, it's just business. It becomes more personal than maybe it needs to, but I think it's natural. I wish I knew how to diffuse that. The best lawyers can at least kind of put it aside and say, hey, I'm the professional here, and not get drawn into that personal conflict. I meet too many that don't have that ability to stay above the fray.
Olga, what do you think?
Well, I've been generally fortunate because on the other side of the V, I do tend to run into just another human being trying to do the best for their client. And I think that if you start at the very beginning of every interaction with somebody from this place where you assume that everyone's coming from a good place, then I think it adds to a conversation so that it doesn't make it a zero-sum game. It's not about one person always winning or one person always losing. And it's about demonstrating humanity at every step. So for example, when I have a case that I know is going to be a very difficult case for my client, and I depose the plaintiff, I want my client either in the room with me if we're in person or on the camera because they need to see the human being at the other side of the camera. And that nothing makes up for you experiencing someone else's humanity. I can write the most beautiful, floral language in a report to my client that says this is the best, person I've ever met in my entire life. But if the client doesn't see it, then it doesn't really matter for much. So one is just really kind of using these methods to show your client the real human loss element. And then being very, I suppose the word is um, painting a picture whenever you do get to being in front of a judge or a mediator or a neutral and giving the whole idea. So I think Chris, the way he was describing it, there are some cases in employment law that are really family law cases that are dressed up as employment law. And you're going to have a lot of hurt feelings. And when you write your mediation brief to the mediator, for the really tricky cases like that, I find it helps to have a neutral third party. But when I write that brief, I explain the things. I explained who dated before they started working with the company. I explain, what they wrote in their emails about each other, what they thought about each other, what they feel currently. You tell the story with the human element at the forefront because you need this neutral to see what before they get in the room they need to see what's going to be on the other side of the camera now that most mediations are online. I find it really helps to not just stick to the very cut and dry facts, but also get into context, paint kind of this picture of what are these real human emotions that are at stake once we get to this point in our case.
So I told you these are good, reasonable people, right? Yeah, you're good sense of it as we go along here. So this is something that I know is distinguishable when we're talking about the humanity, but not necessarily when we're looking at the statutes and the regulations. So a technical wage and hour violation versus one that's deliberate is treated more or less the same in a PAGA claim. There's no distinction, which can sometimes mean that a company that was trying to do the right thing but didn't do it right gets hammered, and that hurts. It can really put a small company out of business. And at least from what I've been able to do with rough surveying, most small business owners have no idea they're supposed to have a workplace prevention
The
violence.
workplace violence prevention plan?
Yeah, it's like, well, it's both internal and external, right? The threat could be inside, someone runs amok, or it can be someone coming in from the outside. And again, if you don't know about it, ignorance of the law is no excuse. So, in your ways, how do you deal with the fact that there's just a whole lot of stuff out there that they have to know?
So for me, I have sort of the privilege, if you will, of getting to choose my cases, right? And um, you know, I'll do wage and hour cases, but I want a wage and hour case where somebody has been seriously done wrong in some way. For instance, denied overtime in a position that everybody really should understand. This isn't something that's managerial. You pay these people by the hour so that if they work overtime, they get paid overtime as we've decided they should be since the 1930s, right? So I just myself just stay away from what I consider to be the super technical violations. It's just not for me. Um, I want to represent folks who have had real harm done. And so, it's kind of, I suppose you could call it a cop out to your question, but that's the way I deal with it. I just stay away from them.
Okay. And that's a good choice, right? You get to make that choice. Olga, you don't always get to choose because sometimes these things
Right.
just come flying at you, right?
Right. I really, I don't. And I end up having to tell my clients way more than I would like that I recognize that they're doing the best that they can, that they try to do everything right, but it really, a lot of the stuff really is unknowable. And when they ask me things like, but we trust everybody and we know they'll go eat when they're hungry because they don't want to leave the store empty. And we know that they'll do X, Y, and Z. And are we supposed to hold their hands? Are we supposed to punish them for working too hard for us? How do we curb this? And sometimes it's having to explain that it's counterintuitive at times that the number it has to be down to the minute, and that you have to keep such close track on these. It kind of it's paternalistic in a lot of ways because it does remove a lot of agency from the company or the employee, and in some cases it's devastating. So, for example, a lot of the individual caretaker cases, the live-in caretaker cases, where you get a lawsuit saying, oh, well, I was working 24 hours because this person, they needed me to live in their house. So I didn't sleep and now I need X amount of hours of overtime. And you owe me millions of dollars now that you've lost grandma and you need to pay me as well. So it can be a lot of setting expectations and, I've had clients saying, like, they cry on the phone with me and they say, well, I went home and I prayed on it and I feel better about it now. I've come to accept it. So it's almost kind of a counselor route saying you're not a bad person, but, this is really hard to do sometimes. And just giving someone that understanding and the listening and saying, now you know for next time. And this is just sometimes it's going to be a cost of doing business because of the way that the laws are structured. I also, at the end of the year, when new laws are going to come in, I put together a packet of things to expect and changes. When I have a tiny company client, I tend to have them have documents that show, things to look out for that a lot of or companies don't know about. We have our Compliance Matters newsletter that my firm puts out whenever big changes are coming to employment law. So it's just a lot. We're in the age of information, and small business people like everyone else, it's just there's this barrage that comes to you every day, and it's a lot to keep track of. So it's very much communicating, understanding, and then talking to opposing counsel. I can say, there's a lot of when you do come when it comes time to having these discussions, the idea that the company is going to go bankrupt if this doesn't happen. Especially a lot of my clients, they're tiny clients. I've been in a mediation before where somebody said, "Well, can we make this agreement confidential?" And I said, well, you sued your in-laws and they own the company, so they're going to know that you're the reason that they're losing this money. So a lot of times it can be very much just explaining to people what to expect. And that sometimes it's counterintuitive.
Okay. I can see where that sometimes could be almost even comical about confidentiality when the cat's been let out of the bag and has run amok all over the neighborhood.
Yes. I said, I told the mediator, I know she probably doesn't want everyone to know that the settlement means no one else gets Christmas bonuses of the company, but it is what it is.
Or no Christmas presents from the in-laws that
Yeah,
year.
I probably know awkward family dinner that year, I'm sure.
So this, as you were talking, Olga, I was thinking of something else where you both have to deal with this, and it probably drives you nuts from time to time. There's also the workers' compensation system, which is very regimented, and sometimes, Chris, you're dealing with a plaintiff who has workers' compensation counsel, and sometimes, Olga, you're doing exactly the same thing. The company's got workers' compensation, and they're on a completely different path as to what's going on there. How do you deal with that problem?
Very carefully, John. Um, it can create, even though, as you say, they are two wholly separate systems. In many cases, there's so much crossover that it can create problems if you're not mindful, particularly disability cases or where I see this arise. So, you know, I'll have a case. It doesn't matter that it was workplace or non-workplace. All that matters is the person had some kind of disability and they weren't accommodated in the way that they should have been. They should have been offered, let's say, an alternate position. They should have been allowed to work from home. At least that's what I'm saying as their lawyer, right? But if it's because of an injury that happened at the job, then they may have at the same time a workers' comp case. And, while workers' comp cases resolve and are not supposed to affect a civil case, um, you know, it, they can. It can affect damages. It can affect treatments that become important. The leave that you get for workers' comp can be different than the leave that you're supposed to get for disability. So it's all I can do is, make sure my client understands that it's very important to tell me things, because they don't always feel like, you know, you should know, or they just think you'll automatically know somehow by magic that, this stuff just gets imported into your brain from the workers' comp system. And to try as best you can to have an open line of dialogue with workers' comp counsel, but that is often very, very difficult because they are incredibly overworked and underpaid. And so, you know, uh, um, they don't get paid to have conversations with me on the phone and keep me up to date. And so it can be extremely challenging. And I'm not faulting them for it. They're doing the best they can, but it's a real challenge for me.
Yeah, the system really puts heavy burdens on the attorneys on both sides. It's a volume practice, and sometimes details just go flying by. Olga, what do you have to say on this one?
I am lucky because I don't have the same issue that Chris does, because Workers' Comp Defense Counsel probably also has their billable hours requirement, just like I do. So when we talk to each other, all of that is working the case. So we have these long, luxurious conversations where we talk about injuries and we exchange deposition transcripts and we talk about medical people or medical records that have been subpoenaed. Um, and it's the same thing. It's picking up the phone and then just, but it has to be, it's reciprocal, right? So we share. I tell counsel when the date of our deposition is, and they share information with me. And so far, I've had a lot of luck being able to use that as another source of information. Um, but it is hard sometimes to settle cases when I have a client saying, "Well, this dude, he's suing us with you. He's brought a workers' comp case, so we have a counsel trying to settle that case. He is bringing a union. We got the union arguing a grievance, and he filed the DLSC case, and we got the CRD knocking on the door." So if people talk to each other, it's more of an incentive for the employer to settle if they know they can get rid of everything in one swoop, as opposed to this piecemeal type of settling here and there. So I guess my advice on the plaintiff side is if you can come in and say, all right, like all of us are on the same page and we will all go away, even if it's a little bit more money, I think it adds a little bit more to the bargain. Because there is something to be said about being 100% done with something and moving on.
That's certainly true.
It's good
So
advice.
last question is very trendy, and it's on everybody's mind, whether you, regardless of what you may believe about how the policy should be and how it should be enforced and so on. We have a lot of disturbances at companies because of immigration issues today. So coming back to the topic of compassion, are you finding this impacting your practice? Are people coming to you, Chris, for help instead of to an immigration attorney? Are they coming to you, Olga? Companies coming to you because they want to help workers who, may have worked with them for years, and they're concerned about being picked up even though they've got the right to be in the country. I mean, how are you dealing with this problem?
It's a great question. It has not affected my practice yet. Um, I don't know if it's a function of people just being afraid to reach out at all to anybody. But it hasn't affected the people who are calling my firm and seeking help. Asterisk, maybe it's going to. Um, but not yet. So I'm quite curious to hear on the defense side, because one of the cases I worked on years and years ago had a big immigration component, and it was sticky back then. And this was when things were relatively calm and peaceful in that arena. So I'm curious to hear what Olga has to say if it's coming up in her world.
Well, it impacts me personally. I'm a first generation of, I was born in the US, but my mom wasn't a citizen when I was born. I live in Whittier, which has been one of the places that has been hit early and often with ICE raids. So people in my community have been taken from various businesses in the area. So on a human level, it has been devastating. A lot of what we're seeing here is kind of the reason my family is no longer in Mexico. So that has been difficult. But on an employment level, there are a couple of things that California law is it. So I guess I could start at the beginning. In 2018, the Immigration Worker Protection Act uh, became effective, and that was AB 450. And that is a California specific law that protects private areas in a business from uh, intrusion by ICE agents. So, under that law, businesses have a duty to all of their employees that they have to prevent access to private areas to ICE unless there is a judicial warrant, and this is not an administrative warrant. So one thing you want as an employer to be able to do is know the difference between these warrants, know which one is a valid warrant under this particular California law. The other thing is I-9 inspections. If you when you receive a notice of an I-9 inspection or an I-9 audit, you have to give notice to your employees that that is happening as well under this California law. Uh, you need to inform your employees about their rights in California. So even though I don't have any employees because I am an associate at a law firm, I do carry the copies of the immigrant red card in my wallet with me, and I give it to, when I go to restaurants, I talk to the people in the kitchen, I give them copies, I give them to the custodial staff. When I see someone cleaning, I say, here, please, take care of yourself. And on one side in Spanish, it'll give you what your rights are. And on the other side, you just hand the card itself to ICE. You don't have to open your door. Um, so as an employer, the AB 450 said, it's part of your duty to inform people of your rights. You want someone at your location to know what to do if there's a raid, to have adequate training, to have these raid protocols in place for when and not if it happens, based on what been seeing in Southern California. And then you have to refrain from retaliation. So if someone refuses to speak with ICE, there is no, you're fired for your silence or things like that. And what I have noticed is that, or maybe just the public sentiment expressed to me because of who I am, most people have been overwhelmingly supportive of their neighbors that are being harassed and picked up by ICE or by other federal agencies. People don't want the people that are here working, especially at their jobs, to suffer from, just I guess a big question mark at the end because there's a lot of confusion as to what's happening there. So definitely having someone at the workplace that is familiar with an employer's obligations uh, and that is able to pass along the information that needs to get passed along. I haven't seen any cases yet where somebody has made a claim of retaliation because of an ICE raid, or you haven't complied with this law. But as an employer, I mean, it's not good for business either to have people don't want to come to work when they suspect that something could happen to them and they're not protected. So you want to be the kind of employer that has a safe workplace for your employees in general and especially right now.
Thank you, Olga. That is something I think that employers don't generally know enough about. So that's very helpful to spread the word.
If you
And
have a place for links, I can send you a link to the Immigrant Legal Rights Center's Red Card. And there's even posters that workplaces can put up that say, ICE is not welcome in these private areas.
yeah, get that over to me, Olga, and we'll see what we can do about embedding it or getting it out in some other way. So we could keep going on topics for a lot longer, but I really want to thank our two very esteemed attorneys today, Chris Weaver and Olga Peña, for sharing some time with us to talk about things that are really important to all of us. Whether you're an employer or an employee, you're all in the same workplace together. So this is important stuff to know about. This is John Tulac saying farewell for now. We will see you again next week with another episode of Professionals of the Inland Empire. So long for now.
Thanks for watching or listening to, depending on the case, the Professionals of the Inland Empire show with your host, John W. Tulac. If you have a suggestion for a guest, email him at jwtulac, that's JWTULAC @gmail.com. jwtulac @gmail.com.